Sure, I've got it all. Good morning, Your Honors. May it please the court. My name is Megan Peak Luca. I am here today on behalf of the appellant, Valerie Brown, and I would like to reserve 5 of my 20 minutes for rebuttal, please. I'd like to start with the trespasser argument. In their motion for summary judgment, Tampa General said Brown was an invitee. 4 business days before the hearing, they changed their argument and said she had become a trespasser. They did not raise trespasser as an affirmative defense. No discovery was conducted on the matter. On a fundamental level, for the court to have reached it, courts are not authorized to award relief not requested in the pleadings, and to do so is reversible error. That's Abbott v. Abbott, 98 Southern 3rd 616, which is this court's case. We would argue that the court shouldn't have reached the trespasser argument, but even though she did, it still fails on the merits. Originally, the court said that Brown was a trespasser because she refused to leave. In response to the fact that she considered a reply after she held the hearing, and when I asked to be heard on those issues and to ask questions, she said that was my ruling. So we filed a motion for reconsideration where we attached an affidavit, and the affidavit flatly said that Ms. Brown said, I never refused to leave. It was while I was complying with the nurse's request and saying goodbye to my dad that Timothy Kyle attacked me. So in response to that, the court changed course and in the order on reconsideration said that visiting hours had ended and she had been asked to leave. But there is no evidence that Ms. Brown refused to comply with a request to leave, and she would need to do that in order to become a trespasser. The 2 places that Tampa General relied on from Ms. Brown's transcript were, so after 6 or 7 times of asking for help and them telling me that he would be okay and the video cameras were monitoring and they had live people and that I had to leave now, I was trying to tell my dad, but he wasn't all there. I was trying to tell them that if anybody came to talk to him to press this button, the call button, which was his emergency nurse button. I was leaned over my father's bedside whispering it, and he opened his eyes. He was looking at me, but all of a sudden he kind of yelled. And for me, and the way that he was, it was a big deal. And I turned my head, and that's all I remember. I got hit leaning over the bed. There is nothing in that says someone told her that visiting hours were over, and she was saying, I'm not leaving or refusing to leave. TGH's second citation was, after complaining multiple times to the nursing staff and asking for help, did the nursing staff just finally ask you to leave? Yes. While you were leaning over to whisper to your father to make sure he knew about the call button, is that when the crazy person sneak attacked you with a walker and bashed you in the head? Yes. There is nothing about that that makes Ms. Brown a trespasser.
I recall something that one or more of the briefs, she did not want to leave until her father had been moved out or the other fellow had been moved out.
Yes, Your Honor, that's at 2592 in the transcript.
And I can't consider that as a refusal.
Well, Your Honor, you have to construe that in the light most favorable to Ms. Brown. And what she said was, so she said, I didn't know if he was on drugs or what. And I'm reading from 2592. And she says that he kept getting up. He got up several times. I noticed the alarms weren't going off and I tried to tell the nurse. And after like the 6th time, I asked for a manager. And then she guaranteed me that there were video cameras in the room and nothing would happen. And then it happened again. He jumped up and was screaming again that there were dragons. And he went in and he got his own nurse to show her. And now I was just trying to stay by my father's bedside because I was afraid, because my father was snoring and it agitates those types of people. So then I had that nurses go get me Leanne, a nurse manager again. And this time I said, no, I'm not leaving. And you construing that in the light most favorable to Ms. Brown, it was, I'm not leaving until you do something for my dad. There is no evidence that anyone said visiting hours are over and you have to go now. The only evidence is when they told her, and this is on page 2595, they said I had to leave now. And so then she complies. And here's another thing that's important. She says, I'm not leaving until you get my dad some help. So they take her, this is 2593, to see the camera room. And they say, look, there are people monitoring it. If he gets up, she says, there was a live person for me not to worry. They gave me their word that we were safe. And she says, and then they left. So the 2 nurses that she had asked to come in, and she said, I'm not leaving till you do something. They take her to see the camera room, and then they leave her. and a nurse came in to change my dad's IV bag, and she tries to tell that nurse, you don't understand, this is a real problem. And the reason that that is important is because the restatement says that the conversion from an invitee to trespasser will depend on whether the possessor does or does not consent to his remaining on the land. When she goes and gets these two nurses and they say everything's fine, and then they leave and she continues to remain there, and a nurse is, changing her dad's IV bag and she continues to stay on the property, clearly TGH consents to her remaining there. Also, none of the cases that TGH cites, because there isn't one, say that a person becomes a trespasser the minute that visiting hours are over. What the second restatement says is that an invitee ceases to be an invitee after the expiration of a reasonable time within which to accomplish the purpose for which he is invited to enter. And this is from Henson v. James M. Barker Company. The question of what is reasonable time is a question of fact unless the facts are undisputed. Here, there is zero evidence of how much time passed. The only evidence is Miss Brown's affidavit, where she says, it was while I was complying with the nurse's request and saying goodbye to my dad that Timothy Kyle attacked me. So in this case, the trial judge had to make a determination that an unreasonable amount of time had passed between the nurse saying visiting hours are over, you have to go now, and her leaving. And again, this wasn't presented in the pleadings, no discovery was taken on it. So
with the idea of a reasonable time to leave, when assessing that, would you factor in her desire to ensure that her father was safe before she left? Could a jury say that was a reasonable thing for her to do?
Absolutely, Your Honor. And I would also point out that the only case that the trial court cited was Boyers v. Radiant Group, which is a second DCA case from 2007. And in that case, this court actually reversed the trial court for finding as a matter of law that someone was a trespasser. I want to talk now about undiagnosed and the bird policy. The court said that imposing a duty sounding in premises liability to protect hospital visitors from patients with undiagnosed mental illness would require a duty of clairvoyance. Diagnosed or undiagnosed is not the inquiry, and there is no clairvoyance required. The inquiry is whether it is foreseeable to TGH that there is a zone of risk when people exhibiting behaviors that TGH has itself identified as being indicative of potential violence, when those people are in the presence of anyone in the hospital, visitor, orderly, security, nurse, and TGH takes no action in response to their behaviors. The focus is on behavior, not diagnosis. In Smith v. Florida Power and Light Company.
The record reflects also that the doctors that examined him said had they been alerted to his subsequent behavior, they would have changed their view of whether he was a danger. Right?
Yes, Your Honor. In fact, the attending said that within a reasonable degree of medical probability, he was psychotic at the time that Ms. Brown was attacked, but no one told the doctors.
The nurses had not alerted doctors to his behavior.
Yes, Your Honor. All of the people who saw him, even the first-year resident who treated him, said, yes, I made my diagnosis, which his attending disagreed with, based on what I saw at that time. But there was a passage of hours between when these doctors saw him and when he attacked Ms. Brown.
There's no indication Ms. Brown was clairvoyant, right?
No, Your Honor, but
She certainly saw that he was a problem.
exactly,
She's
Your Honor.
not a doctor.
Exactly, Your Honor. And she was begging them to take action. You heard it, it's throughout the testimony. She said 6 or 7 times, I would beg anybody who came in the room, please do something. So the BERT policy, this court says that whether a duty is owed is to a particular defendant, to a particular, start over. It's a case-specific inquiry. A duty is owed by a particular defendant to a particular plaintiff based on particular circumstances.
When you say that, here's my problem with BERT policy. Is that a question that goes to a breach of a duty? Or does it go to establishing it?
So, Your Honor, Under the unique circumstances of Burt, I think it goes to both. Because here's the thing, a foreseeable zone of risk, and this is from McCain versus Florida Power, which is the seminal case on duty. In that case, the Florida Supreme Court said that there could be no question that Florida Power had the ability to foresee a zone of risk. The extensive precautionary measures taken by Florida Power show that it understood or should have understood the risk involved. And here, the reason that Burt goes to both duty and breach is because the Burt policy is the embodiment of TGH's extensive precautionary measures and what it understands about the dangers of people demonstrating behaviors indicative of potential
So it
suicide.
goes to the foreseeability aspect of duty.
Yes, Your Honor, I believe it does. And I believe that it also, Judge LaRose, goes to breach because at trial, the attorneys would say they had this policy, they had these behaviors. Timothy Kyle was demonstrating 4 of them. TGH doesn't dispute that. They didn't follow their policy, therefore you should consider that as evidence of negligence. But for our purposes on the duty inquiry, the question is it foreseeable to TGH that there is a zone of risk if people are demonstrating behaviors indicative of potential violence and TGH does nothing in response? Does TGH create a zone of risk?
Until he slammed her with the walker, he was doing some pretty bizarre things, but I don't recall that he was doing anything to suggest violence. He was roaming the halls and seeing dinosaurs, but he wasn't pounding the walls, he wasn't beating up on his nurses.
So, Your Honor, the Burt policy lists A through N, and they title it as behaviors indicative of potential violence may include. And in this circumstance, the brief details that Mr. Kyle was demonstrating at least 4 of those, and TGH doesn't dispute that. TGH does say, now, wait a minute, his weren't particularly violent. And on that, I would send you to R603. It's a chart, Your Honor. And it differentiates a code Burt from a code Gray. For example, code Burt, patient's level of anxiety is interfering with care. Code Gray, patient physically aggressive towards staff or other patients. Code Burt, new onset confusion. Code Gray, threats of violence made towards staff or other patients. So in this circumstance, Your Honor, the code itself, and these are all things, everything that I read to you is one of the A through N in the Burt policy, but the Burt policy itself differentiates and says, look, if they're being physically aggressive, then you need to call a code Gray, which is escalated above a code Burt. But the point is that even if they're just demonstrating a level of anxiety interfering with care or new onset confusion, even that is something that the hospital recognizes that you need to take action in response to. And the only reason that you would need to take action in response to it is if the hospital recognizes that there is a risk of danger. And the policy itself, and this is at R600, says that the behavioral emergency response team is designed to have a team of trained staff members assess and respond to individuals demonstrating disruptive or alarming behaviors, just disruptive or alarming, to maintain safety. The purpose of the team is to A, B, C, D, E, F. D is maintain a safe and therapeutic environment for all. The policy, like in McCain, demonstrates that Tampa General had an understanding that there was a risk to the safety of the people in the hospital. It's to maintain a safe and therapeutic environment for all, not just for patients, not just for nurses, for everyone in the hospital. And Your Honor, where TGH has identified behaviors indicative of potential violence, and they require early and immediate assessment of any person meeting any of these criteria in order to maintain safety for all, it defies logic for TGH to tell this court that it is unforeseeable as a matter of law that someone could become violent in the hospital after demonstrating multiple of the behaviors indicative of potential violence. And I'll save that for rebuttal. Ms. Brown's not asking for a duty of clairvoyance. She is asking for protection from something that was a reasonably foreseeable risk. And she wasn't asking just based on the Burt policy. There were also the 39 reports. Now, the court said that the 39 reports made it foreseeable that a patient could attack nearby people who work at the hospital. but it was totally unforeseeable as a matter of law that a patient could attack a nearby visitor. And that is totally inconsistent with this court's ruling in Bellevue versus Frenchies. There, the court said admissibility of a given incident should not be based on whether it was similar to what occurred in the case. Rather, it must be based on whether or not the event put Frenchies on notice that the attack resulting in Miss Bellevue's injury was foreseeable. And for that, the court cited Shelburne, a 4th DCA case, that said a rule limiting evidence of foreseeability to testimony concerning prior similar criminal acts would lead to results contrary to public policy. Foreseeability is determined in light of all the circumstances rather than by a rigid application of mechanical prior similars rules. And here, 39 patients attacked people in the hospital. They attacked security, they attacked nursing staff. But in Timothy Kyle's hallucinative state, he could have just as easily attacked a nurse had a nurse even been in the room. Because remember, the nurses said visiting hours are over, it's time to say goodbye, and they left her to say goodbye to her dad. But had a nurse been standing there, Timothy Kyle could have attacked the nurse. Why would Tampa General owe a duty to protect the nurse, but not a duty to protect the person standing 2 feet away?
Ms. Libby, you're into your rebuttal time.
Thank you, Your Honor. I'm going to eat up 1 minute to say this. By analogy, Tampa General's argument would be if we applied it in Bellevue. In Bellevue, it was patrons attacking a patron. And this court said that it is possible that a night cook being stabbed in the parking lot, patrons using vulgar language, a fight in the parking lot, all of those things could be relevant to foreseeability. And here, our position is that what the court was basically saying is that these patients attacking other people in the hospital would only be relevant to show that patients could attack hospital staff, and it couldn't be relevant to show that they would attack a visitor. That would be like saying that evidence that patrons attacked bartenders could be relevant to show that it was foreseeable to the bar that a patron could attack a bartender, but not that a patron could attack another patron. And that would just be silly. So, Your Honor, I will save the rest of my time for rebuttal. Thank you.
May it please the court, I'm Brian Hull on behalf of the Appellee Florida Health Sciences Center, Inc. 70 minutes, that's all the time that elapsed between the completion of Dr. Terrell's psychiatric exam of Mr. Kyle and the attack. And in that examination, he found Mr. Kyle posed no risk of harm to himself or others. The whole theory that's being advanced here by Ms. Brown is that a hospital owes a duty sounding in premises liability to second guess that medical judgment. That a hospital should have reasonably foreseen that this patient with an undiagnosed mental illness who had just undergone a psychiatric evaluation and was found not to be a threat would suddenly attack a visitor without provocation. The facts and circumstances here are clearly very upsetting, very unfortunate, and very tragic, but the trial court correctly found the hospital did not have a duty to protect Ms. Brown from this unprovoked attack.
But to the extent duty somehow interplays with foreseeability, I don't know how statistically significant it is, but there were 39 instances of patient violence against staff. And you're telling me that I read the briefs that you can't apply that to patient on visitor.
Yes, there was a significant difference in the 39 incidents that happened in this particular incident. And that is, they involved either security personnel or other staff members that were trying to restrain someone, often who was in police custody or who had been involuntarily committed under the Baker Act or the Marchman Act. Or it was a situation of nurses or other medical staff trying to provide care to a patient that the patient was resisting. And the patient was resisting that type of care. And what's absent there is any sort of attack on any visitor who was not even interacting with the patient when that incident occurred. There were no sudden, random, or unprovoked attacks like what happened here. And so, yes, we would submit that those incidents did not make what happened here reasonably foreseeable. They're not something that should have put the hospital on notice that I need to protect visitors when visitors from these sorts of incidents when a nurse is trying to provide care to a patient or when security is trying to restrain somebody. I'd like to turn to the trespasser argument. And in this case, the setting is critically important. This was October of 2020, in the height of the COVID pandemic. And the hospital had imposed very strict visiting hours during that time. And during those proper visiting hours, we don't dispute that a hospital visitor would be an invitee. But a visitor ceases to be an invitee after the expiration of a reasonable time to accomplish the purpose for which she was invited to enter and remain on the property. And the undisputed facts here are that visiting hours were over. Ms. Brown had been asked to leave repeatedly, and yet she was still there. She admitted in her deposition, I would not leave right away. She said, no, I am not. She testified, I said, no, I'm not leaving. Her father gave nearly identical testimony. And the affidavit that she submitted later on didn't change this. It focused on the fact that no one threatened to call security, or no one tried to escort her out, or no one told her she needed to move faster. But that's not relevant to the key question. The key question is, did a reasonable time to accomplish the purpose for which she was invited to be on the property expire? And Ms. Brown has never said that a reasonable time for visiting hospital patients extended beyond the limited COVID visiting hours. I do want to address a couple of points that were raised in the reply brief. The reply brief argued that whether a reasonable time had passed after she was told to leave couldn't be determined on summary judgment. And the first point I want to make about that is that was abandoned. That was not something that was ever raised in the initial brief as a ground to challenge the summary judgment. And it's also not the test for when someone loses invitee status or when invitee status expires. The question was whether a reasonable time for accomplishing the purpose for which she was invited had expired, not how long it took her to leave after the fact.
So that may all be true, but why don't you respond to her point about how late that argument?
Sure. It was raised after, in response to summary judgment, she admitted that it was an undisputed fact that she had remained on the property after she'd been asked to leave. And so we pointed that out in the reply. And then we all went to the hearing. The hearing addressed that issue. And then the trial court ultimately rules on the trespasser ground. Thereafter, she moved for reconsideration, submitted an affidavit, and said, I recognize there's a due process issue here. And she said, but there won't be a due process problem if you consider this affidavit. And that's exactly what the trial court did in addressing the issue on reconsideration, and gave a thorough analysis of why she was a trespasser at the time of the incident. And I would add, as we argued in our answer brief, that the new summary judgment rule specifically allows a trial court to grant summary judgment on grounds independent of the motion, on grounds that haven't been raised in the motion, so long as the non-moving party is given notice and a reasonable opportunity to respond. And that's exactly what happened here, the way this played out. And we also cited a few cases in our answer brief where courts applying the federal standard have allowed and affirmed summary judgment on the same grounds where somebody has raised it, where the non-moving party raised it, and then it was addressed on reply. In this case, what happened was not consent. There was no evidence of consent. She was repeatedly asked to leave. And at that point, when she's asked to leave, she's no longer invited to stay on the property. In other words, the invitation has essentially been revoked when she's been repeatedly asked to leave. And by not leaving, she became a trespasser. The other issue from the reply brief that I wanted to address was that
If you take her version of the facts, it's pretty bizarre that you would expect this lady to leave with a very concerning view of, did her father say anything?
Considering the circumstances here, during COVID, limited visiting hours. She's been told to leave. And the trial court sympathized with the situation, understanding that it's
Well, apparently she did.
expressed sympathy for the situation, but ultimately,
Which did not really
Yes.
factor in the fact that this woman, I'd say arguably reasonably, wanted to stay until she was sure her father was safe.
and I don't dispute that she wanted to stay longer, but that doesn't extend the
So
scope.
did COVID relieve the hospital of any responsibility to this person after visiting hours expired?
To the patient, absolutely, but to the visitor who had overstayed the scope of the invitation, I would submit
to Miss Brown, they even took her, look, we can watch him, nothing's gonna happen.
right. And the reason that he was put on video monitoring was to obtain more objective information. They knew he was acting oddly.
I mean, why do you need a doctor's diagnosis to see that this man is a problem? You keep saying, well, the doctors had a value. I mean, Ms.
Well,
Brown certainly saw it. She's not a doctor.
There's a difference between somebody exhibiting odd behavior or even having a mental illness and being violent. And that was,
Well, and that takes you back to the Burt list.
yes, and what the Burt list represents is behaviors that fall within a range. What has been pointed to here is increased agitation, delusional or paranoid behavior, increased anxiety.
There are dragons in the room. And he's running out to get the nurses to come look at the dragons. He's obviously agitated.
Yes, he is obviously agitated, but he's never shown any indication of violence here, and that's a big difference. And with
But
this,
wait till they're violent before you do something? Is that what your understanding of the Burt policy is?
what we have is a range of behaviors that the trial court looked at the list and said, well, wait a minute, I wouldn't feel like I wouldn't feel like I needed to restrain my kids if this were happening. And she says, I mean, behavior, shoot, I should restrain myself like every Tuesday. You can pick anything off this. And so these are a wide range of behaviors, and where do they fall on?
That were concerning enough to the hospital that they created this policy and they included them in the policy. So I really don't know what relevance it is that the trial court thought those behaviors were okay, because we're talking about the hospital.
And what we're talking about is a range of behaviors and where they fall on that range. And this person had been evaluated by a psychiatrist, evaluated by a number of nurses who none of them saw fit to call a Burt based on this behavior,
Well, that's
because
the problem, isn't it, in this case, that none of them saw fit to do anything about this behavior.
it hadn't reached a level of that they saw it as indicative of violence. Someone being agitated, minimally agitated, is that indicative of violence?
He's pulling out his IV, he won't stay in bed, he's running down the hall screaming about dragons. I mean.
And this, none of this was violent, though. He was not.
By video.
This is not a situation where he was, say, banging on the wall with a walker. He was not making any threats. He never said, I'm going to hit someone. Nothing ever like that. So what we have is just a level of agitation. He is jumping out of bed and running down the hallway. Yes, but he has done nothing.
It seems to me that the Burt policy is to catch people and evaluate them before they start becoming violent. Am I misunderstanding it?
I think that's a reasonable assessment of it. And here's someone who had just been evaluated by a psychiatrist.
You just then, you say 70 minutes, it's over an hour before. And as I read this, it looked like he was deteriorating very quickly.
Yes, and I would say,
Getting worse very quickly.
and the nurse Bird, she made a note in there that she reported that to psychiatry, where he had just come from, who had just evaluated him. I think there was an argument that his
Is
doctor.
that the note that then disappeared? That they couldn't. She said that she created a note.
Yes.
But whatever document she put it in, no one could ever find.
No, she said that she told psychiatry, and then she testified that she told psychiatry. The people who were asked if they saw the note were not psychiatry, they were internal medicine. And so she had reached out to psychiatry, who had evaluated him previously, shortly there before that.
Mr. Hall, your exchange with Judge Kelly leaves me all the more unsettled as to whether we're talking about breach or talking about duty.
In the Burt policy, yeah. What has been argued here is an issue of breach, that they should have called a Burt, that they should have looked down this policy and done something based on what was in the policy. That goes to breach. That goes to breach. But if we're looking at this to say, well, are these behaviors, do they make violence foreseeable? That's my point about the range. There's a range of agitation, and this policy does not make clear where on that range someone is before violence would become, before they would have a potential for violence. And I think that's really the point. There's no evidence that these internal policies and these 4 behaviors in particular represent what is reasonably foreseeable and not merely what is possible. So someone with some agitation, it may be possible, merely possible, that they could become violent, but it's not reasonably foreseeable that it would lead to physical violence. And I want to point to a case that we quoted. It's mental health care v. Stewart from this court in 2005, where quoting the Boynton court, which was another opinion that we cited there. This court said, because of the inherent difficulties psychiatrists face in predicting a patient's dangerousness, psychiatrists cannot be charged with accurately making these predictions and with sharing these predictions with others. And then another case I wanted to point to is
Was that a malpractice case?
this was, I believe it was a case where they were trying to hold a mental health practitioner liable for an attack on a third party.
Malpractice.
I believe it was.
Okay.
Yes.
And you emphasize this is a premises liability case.
This is a premises
We're not
liability.
evaluating doctors here.
That's correct. But the point is, if a duty can't be imposed on the very medical and mental health professionals who deal with this sort of thing on a daily basis, it's even more improper to impose that duty on a landowner hospital who would have to second guess the medical judgment of those mental health professionals who evaluated him.
And the second guess are, I'm sorry, you lost me on that.
Well, what we have here is a doctor of psychiatry who's evaluated and found him not to be a threat. And then so in order to impose the duty on the hospital.
Policy, regardless of that, you have this policy that lists these behaviors and says, if you've got this, here's the protocol.
And what's on that policy?
All I have to do is, and again, I think maybe this goes to breach and duty. All they had to do was follow their own policy. They obviously had an awareness that these type of behaviors could be problematic. And they created this very detailed policy on what to do.
And again, you're right, that does go to the breach issue. That goes to the breach issue. But as far as foreseeability, when you list out behaviors.
I mean, they created it for a reason. It's like they foresaw that these behaviors could be problematic. So we're gonna, for the safety, you acknowledged it was for safety. So for the safety of staff, patients, whatever, we've got this policy and when we see this, we want to evaluate it.
And I would direct the court to the Johnson v. Walmart opinion that we cited from the 5th DCA, which says that policies don't necessarily represent what is reasonably foreseeable as opposed to what is merely possible. And so a business will come up with a policy that may address.
A hard time thinking that it's, and I want to give you a chance to respond to this. I don't know what I'm thinking that it's not reasonable to see a person in this state and not think that they are a potential problem.
And I would say there's a difference between being a problem and being violent. For someone who has never exhibited violent behavior at any point, and Tampa General was familiar with him, he'd been there before and had never acted violently.
Mr. Hall, we help you use your 20 minutes.
Thank you. If there's no other questions, thank you. We would ask that this is a tragic case and no one condones what happened, but we would submit the trial court correctly found the hospital did not have a legal duty to protect Ms. Brown from the sudden unprovoked criminal attack.
One second to organize my menagerie. Your Honors, we are not asking to disagree with residents' diagnosis. That's going to be a breach issue. What we are saying is that Tampa General has a duty to keep people safe from patients who are demonstrating behaviors indicative of potential violence. And the fact that they have made that list and that they have a 15-page policy about it is evidence that it is reasonably foreseeable to them that there could be a danger. I mean, they say it is for safety. And in that Johnson case, what the court said is that absent some evidence to establish that the internal policies themselves or some specific portion thereof represent what is reasonably foreseeable and not what is merely possible, we aren't going to look at internal rules. And by the way, in that case, you were talking about one line. Don't chase shoplifters into the parking lot. The Burt policy is 15 pages long. It is detailed and its purpose. It says the purpose is to maintain a safe environment for all. Also, I question how it is
So
possible.
help me out with my repeated confusion.
Okay.
So by establishing the BERT policy, TGH has recognized that there is a zone of danger
By
and therefore taking on a duty. Visitors to the hospital.
Yes, Your Honor. In the facts of this particular case, I am not arguing that any company's policy creates a duty. What I am saying is, as this court recognized in the Smith case, under the particular facts of this particular case, this particular policy is a recognition that when people are demonstrating behaviors indicative of potential violence, that there is a strong possibility that that will escalate, which is why the policy requires early and immediate intervention to establish a safe environment for all. That is a recognition of a zone of risk. And that's what duty focuses on. It's not diagnosed or undiagnosed. It is, hold on, I tried to write it down. I lost it again. That TGH recognizes that when people are demonstrating behaviors indicative of potential violence, that there is a zone of risk around those people if TGH takes no action in response. And the talk about that range, that there are some that are physically violent and some that aren't, that goes to breach. That goes to, well, sure, he was demonstrating things on the list, but that wouldn't tell us that he was going to do what he did here. That's an argument you make to the jury about breach. So I think that the policy under the particular facts of this particular case is relevant to both inquiries because the policy demonstrates TGH's knowledge. It is, Judge Kelly, as you recognized, it's the McCain case. It's the extensive precautionary measures that they were taking, that TGH was taking to prevent violence. I would ask the court how it is possible to determine that a reasonable time expired when there is no evidence of how much time passed. And again, the testimony is that Ms. Brown said, I insisted that the nurses go get me Leanne again. And this time I said, no, I'm not leaving. And I want him moved. And you can construe that two ways. And you got to construe it in her favor, which is go get me that nurse. When the nurse comes in, listen to me. I'm not going to leave here until you have confirmed for me that my dad is safe. He's 70, he's toothless, he's tied to the bed, and that kid is acting like a maniac. And I know what it looks like, and I'm scared. My dad's snoring. He could attack him. Protect my dad. I'm not going to leave here until you promise me that you're going to do that. There is no evidence that someone told her, you have to leave now. And in response, she said, no, I'm not leaving. There is no evidence that multiple people told her over multiple periods of time.
Looking, you're at the end of your level time.
Thank you, Your Honor. We would ask that the court reverse and remand for a trial because as a matter of law, it is not possible to say that it was not foreseeable to Tampa General that someone demonstrating behaviors indicative of potential violence could in fact become violent. Thank you.
Thank you, Beth. Next case is